Pioneer. I'm Judith Royal. Our league serves the communities of Arlington Heights, Mount Prospect, Buffalo Grove, Wheeling, Prospect Heights, and Elk Grove Village. League of Women Voters has been active in advocating for 95 years. The League encourages the informed and active participation of citizens in government, works to increase understanding of major public policy issues, and influences public policy through education and advocacy. September 17th is Constitution Day and Citizenship Day in the United States. This date or event commemorates the formation and signing of the U.S. Constitution on September 17, 1787. That was 228 years ago. This date recognizes also all who, by coming of age or by naturalization, have become U.S. citizens. Tonight's program is an educational program. With so many important issues today involving constitutional law, this overview is an ideal way to become better informed as United States voters. Our program this evening highlights the basics of the Constitution. The League is pleased to present Thomas Glasgow as our speaker. He is founding member and attorney with Glasgow, Beatty, and Olson. Mr. Glasgow has served as Cook County Assistant State's Attorney, Chief of Medical Prosecutions for the Illinois Department of Professional Regulations, and Managing Partner of Glasgow, Beatty, Olson. He is a dedicated public servant and has been a Village of Arlington Heights trustee since 2009. He is the former chairman of the Village of Arlington Heights Zoning Commission, former president pro tem and treasurer of Northwest Cook County Water Commission, and former governor of Northwest Suburban Bar Association. He has been selected as Chicago's top attorney, super lawyers in Illinois, and top 10 criminal lawyers in Illinois. He has served as legal analyst for ABC Morning News Chicago and NBC Nightly News Chicago, Fox News Chicago, CBS, CLTV, and CNN. His awards include Northwest Community Hospital President's Circle and Northwest Suburban Bar Association's Award for pro bono legal services. The League, well, this sounds like a person who really enjoys his profession and sharing his gifts with the community. So now the League welcomes and thanks Thomas Glasgow for giving us an overview of the United States Constitution and the amendment process. He will answer questions at the end of his presentation, so please hold those questions, and then maybe we should raise our hand to be recognized. So let's give our speaker a big welcome.
Thank you very much, Judith. And thank you guys for coming tonight. This is something that I am incredibly passionate about. This has been my life. This is not only my job, but it's something I truly, truly love. You guys may have learned about the Constitution through Schoolhouse Rock. You may have ended up learning about it through civics class. Or you may have ended up learning that, some people got together, some real old guys, and ended up decided to write this Constitution that we live by. What you're about to hear tonight, scarily, in the time that this was written, in 1787, 90% of the people that were out there knew what was going on. They understood what we were about to talk about. The scary thing is today, when we sit and talk, 90% of the people out in public don't understand this document, and they don't understand what rights are contained within this document. So what I'd like to do, and unfortunately this particular projector is not enough to get up there unless we turn off some of the lights, I want you guys to understand that there are certain things that happen during the course of the Constitution. There are certain things that we end up utilizing, and this formulates not only your daily life, but it formulates how we live our lives every day. First of all, you probably know these two people. We're all in the dark, right? You recognize these two people. And there's something about both of these two people, which we're going to talk about. And we're going to talk about during the course of this day. We have Howard Stern over on the far left, and we have John Boehner, the Speaker of the House, on the right. What do they have in common? They both end up having their jobs because of the Constitution. One of them ends up embracing himself in freedom of speech. very first of the Bill of Rights. The other one is a constitutionally protected office that is espoused by the Constitution. Does anybody know who this person is? James Madison. Who is James Madison?
He's a Virginian.
And?
He was the writer of the Constitution.
Absolutely fantastic. If I were to show that to a bunch of school kids, no one has ever picked that out. Not one person.
Dolly Madison's husband.
That's the important one.
And Dolly Madison's husband, you're absolutely correct. He was the author of the Constitution. He was a political crony of Thomas Jefferson. They had so many things in common. In fact, he stayed over at Thomas Jefferson's house so often in a bedroom. They had the Madison room that they named in his home. The preamble of the Constitution, and this is incredibly difficult for you guys to see, but hopefully we can end up leading it off to you. We the people, in order to form a more perfect union, to establish justice, tranquility,
And ensure the events do
The general welfare.
and I can't remember this, do establish and
and to protect.
maintain or something like that. Oh,
Do you remember the Schoolhouse Rock? We the
God. No, I had
people,
none
first and foremost, perfect
memorized,
union.
you know.
All right, essentially there's 6 things that we have with regard to the preamble. The important thing of the preamble, the important factor of the preamble, is the fact that the preamble espouses the 6 things that the Constitution, all of the Constitution, is supposed to end up engendering. Now, if you look at the preamble that you have sitting in the chairs, we the people, in order to form a more perfect union, in order to connectivity between the states, and forgive me because this is unfortunately not as,
Page one.
page 1.
Yeah. Number one.
There we go. All right.
Establish.
Establish justice, so the court system will ensure that everybody is given an equal opportunity in life, to ensure domestic tranquility, obviously to keep the peace within the country, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish the Constitution of the United States of America. Those are 52 words that espouse the entire Constitution. Those items, everything that you see within the Constitution, ends up stemming from this. The Constitution is incredibly interested in the way that it is formed. In other words, when you look at the writing of the Constitution, it's laid out in separate sections. The first 3 sections establish the rule of government. Now, does anybody here know what it is that the Constitution established? Do we establish a democracy?
Republic.
A republic. God, I know smart people. It established a republic. You're absolutely right. It's an interchangeable term in today's society, but it established a republic. And that republic is what we have as a result of sections 1, 2, and 3. Now, which is the most powerful section of government? We're in the midst of a presidential campaign. Which is the most powerful branch of government?
It's supposed to be equal. It's supposed to be co-equal.
No one.
No one? The legislature. And the legislature is the most important and the most powerful, according to the framers of the Constitution. That is why it is number 1. That is why it is section 1. It is section 1 because the Constitution, the drafters of the Constitution, ended up seeing that those 435 representatives and 100 senators are elected directly from the people. Those people are you and me. And they are given more powers than the executive and the judicial branch combined under the Constitution. Of the 2 houses, the senators or the representatives, who is the more powerful?
I would say the House.
Yeah, they have the power
Initiate the
first.
bills.
The House is far more powerful. And that's why they limited it to 2 years. It's more powerful for the very reason that you espoused, is that you articulated the fact that they control appropriations. All appropriations start in the House. For the average person, a senator, there are only 100 of them. There are 435 representatives. The average senator is going to have a lot more clout than the average representative. However, all the power in the House of Representatives resides in those chairs, every one of them. And nothing gets out of committee without those chairs granting that to get out of committee. However, they made sure that this turns over every 2 years because they realized the potential for corruption. Prior to the 17th Amendment, how were the senators selected? They were selected through the state legislatures. And they were selected through the state legislatures so that states would have a check on the federal government. 17th Amendment in 1913 changed that, and we elected the senators directly to the legislature. Part two, the executive branch. The executive branch ends up controlling and describing the qualifications for the president. The qualifications for who shall be president and what powers the president has. The president does not have any powers in time of peace as a commander-in-chief, not technically, but at war he has great powers. With regard to the fact that the president cannot institute any laws. Something that you may or may not know is that executive orders are nowhere to be found in the Constitution. However, the Constitution does allow, with regard to the way that it was originally set up, the executive was to enforce all of the laws of Congress. Congress shall make the laws. They have more power. They coin money. They pay off debts. They end up making appropriations. That is Congress's power. That is our power. However, in the executive branch is supposed to enforce those things. And it is number two, so it's considered the second most important branch of government. The legislative and executive are controlled in the checks and balances. Somebody mentioned co-equal. Co-equal is exactly right. Co-equal was that each branch of government was supposed to lend a check and balance to make sure that the other branch of government did not end up getting out of hand. However, if you have two branches of government, they can override the third branch of government, and that's why there are only three. The judicial branch originally only had one court, and that's the only court that's espoused in the Constitution. That is the Supreme Court of the United States and such other courts as shall be subservient and made up by Congress. So every other court is made up from Congress and rules of Congress. However, the Supreme Court is the only court that is enumerated in the Constitution. That court is to end up giving rulings and interpret the Constitution. Now that's been taken and formulated over the years from Marbury versus Madison and onward to actually interpreting the Constitution to enumerate rights that are not specifically enumerated in the Constitution. Those are some of the things that we'll talk about later. And we're going to have to move this so that we can end up seeing it. So I'm going to move this forward. Hopefully you guys can understand it.
More lights on?
Yeah, I just want to make sure that it's focused. All right, the First Amendment, with regard to the Bill of Rights, that is the Constitution in a nutshell. You've got Section 4 and 5, which we will discuss a bit later, but the Bill of Rights was something that was put together after the Constitution was established. In 1789, they got together, and the Bill of Rights was introduced originally as 12 particular amendments. Those 12 amendments, the first two were congressional districts and congressional salaries, both of which were nixed by the congressional caucus. Now, the congressional salaries came back into the same, was made a part of an amendment to the Constitution with the 27th Amendment, but at the time they said, no, we're not going to go ahead with it forward. 12 were drafted in Philadelphia, only 10 ended up coming forward. With regard, and were approved. With regard to the First Amendment, Congress shall make no law regulating an establishment of a religion, or restricting an establishment of religion, or prohibiting the free exercise thereof, or abridging freedom of speech, or freedom of the press, of the people to publicly assemble, or what? What's the last part of the First Amendment that everybody forgets? Absolutely. You have a right to criticize the government without having any kind of fear of reprisal by your government. Remember the time that this was written. When it was written, this was something that they were in fear of, because when they criticized the government, when they wrote the papers, the king ended up sending out horsemen to end up arresting the people and taking them into custody. The First Amendment we will talk about, we'll talk about the context of what the First Amendment is and why it is in the position that it is. It is the First Amendment because it was one of the most important factors for the people that wrote the Constitution. When they ended up putting together the Bill of Rights, Does the Bill of Rights grant rights? No, it doesn't. These were rights that were felt that they were inalienable, and all we did was codify the rights that God had already given us according to the Founding Fathers. That is an important factor to remember, because those rights are your rights that, under the law, and the courts still to this day see it as that. The First Amendment encompasses many, many different things. Obviously, you can't shout fire in a crowded building. You can't defame someone. You don't have absolute freedom of speech. However, you do have the freedom to walk down the street yelling at somebody. A recent case that came down just the other day in New York, a person decided that they were going to write obscenities on the check that they ended up writing to the clerk. Well, to pay their fine. And you can imagine what kind of obscenities they wrote on the check. He was arrested. He wrote 3 words. I'll leave it to your imagination. But he wrote 3 words, and he was arrested. And they took him in, and they ended up saying, "You're under arrest because you created a disturbance." The court came back 2 years later and ended up saying, no, that is his freedom of expression. He has an absolute right to do that. A gentleman ends up rolling down the street. He extends a one finger salute to a police officer. He's arrested. He's taken into custody. Guess what? It was deemed a freedom of expression. The court has given broad brushstrokes to freedom of expression. Pornography. It used to be that you had to put a period interest at the end. You could not be devoid of any kind of education. There was a lecture at the end of all of the films back in the 60s and the 70s about communism or this or that. Now it's not required. It's something that it grows. One of the beautiful things about both the Bill of Rights and the Constitution is that you'll see that it is a living document, and it's something that the courts continually interpret. The writers of this were absolute geniuses, because they ended up making something flexible enough to make sure that you and I could continue to live by it today. The Declaration of Independence and the Constitution were to work hand in hand, and they would work hand in hand because the Declaration of Independence is sort of like the Charter, and the Constitution is sort of like your bylaws, and they work hand in glove. And the ideals in the Declaration of Independence are to be espoused and are espoused within the Constitution. The freedom to assemble, be able to go out, be able to write about your government. They yell outside Village Hall about something that we may have done with my esteemed colleague. That's their right. It is their right to say the government's wrong. With regard to the Second Amendment, a well-regulated militia, being necessary for the security of the state. The right of the people to keep and bear arms shall not be infringed. This was recently decided in the McDonald case and the Heller case. And both the McDonald and the Heller case, and recently in the state of Illinois, established that the right to bear arms is an individual right. It is not something that is imaginary. It's not something for the government. Because the Bill of Rights is to enumerate rights of the people, the right to bear arms was ended up named a fundamental right that can't be abridged. Now, whether you agree with it or don't agree with it, the Founding Fathers went back and they took a look at some of the writings, and this is my second amendment Halloween costume. I always thought it would be nice to just go with hairy arms and be the right to bear arms.
Is it just the right arm with the bare arm?
Both of them. I just bare arms and nothing else. But Patrick Henry, one of the things that they ended up writing for the Founding Fathers was the objective is that every man be armed. Those writings, the Federalist Papers, other papers, the writings of the Founding Fathers were very important to the courts in determining exactly what they meant. Now, the Second Amendment is an incredibly important right for many people, and you guys know that with regard to the NRA. However, others consider it to be something of an anachronism because we lived in a different world at that time. You have to remember where the Founding Fathers came from. In their countries, they all came from countries where the only people with guns were the soldiers, and the only people with guns were the king's men. Now, this is a living document that's been interpreted. It's been interpreted here that is still one of the fundamental rights and can't be abridged. The Third Amendment, that you shall not keep and quarter troops in people's homes. People may think, no, the Third Amendment, when's the last time we ever heard about somebody keeping and quartering troops in someone's home? This, again, is an anachronism. You guys have watched TV and you probably know about all the immigrants in Germany. Recently, a story came down that the police are going home to home in Germany, knocking on the door to determine how big your house is and determine, do you have enough room to put some of these immigrants on? And they're demanding that those people be placed in the home. That is no different than what happened back in the days when this was written, because keeping and quartering troops in people's homes was a common practice of the British. You had to feed them, you had to make sure that they had a place to sleep, and you had to take care of them during the course of the day. It was a burden upon you. Now, it's not that far from where we were then to see the police come to the house to force you to take someone else into your home. And you can imagine how people would recoil if the government ended up doing something like that here. The Fourth Amendment is probably one of the most important amendments and probably one of the most litigated amendments, especially in my profession, because it is the only amendment that codifies the importance of private property. Your home, Mary, is something that I, as a law enforcement officer, cannot enter at any given time just because I want to. I have to go to a magistrate. I have to show that magistrate that I have probable cause to believe that something has occurred in your home. I can't warrantlessly enter your home. Additionally, you also have a freedom in your person not to be searched. And this is also covered by the Fourth Amendment. A warrantless seizure of a person. If I were to stop you and search you and go through your purse and go through your cell phone, you probably would be a little upset. However, if I had probable cause to do so, I would be protected under the law as a law enforcement officer. If I didn't, and I did it on a whim, then that is a violation of the Fourth Amendment. The most recent case that came down with regard to this was that very thing, a cell phone. And cell phones previously had not been protected under the Fourth Amendment. And the court said, look at your cell phone. We have credit cards, we have phone numbers, we have birth dates, we have secure documents. They become mini computers. So you have to show probable cause. An interesting fact is that there are several courts throughout the United States. There are the magistrates and there are the district court judges. The magistrates are the lower judges under the district court judges in the federal system, and they generally the ones that hear the warrant applications. The FBI or the DEA go in and say, I'd like to search this person's home. I believe there's drugs. We've done several different transactions. I used to approve those warrants when I worked in the prosecutor's office, and I had to sign off on them before they went to the judge to make sure we didn't embarrass ourselves. There was a check and balance system. However, there are times when that public portion is taken out of it. You guys may know of the secret court that they have in Washington, where if they want to get eavesdropping, or they want to do security over here is on you or confidential over here is on you, they can do so. And they can do so, but they still have to go to the FISA court and end up asking for permission to do so. Just because it is a national security issue does not obviate the Fourth Amendment. Questions arise, when does the Fourth Amendment apply? Does it apply in the United States? Does it apply outside of the United States? When they seized Noriega, was that an unlawful seizure? Yes, it was an unlawful seizure, but it happened outside the United States to a non-American citizen, so it doesn't apply. However, if you're a non-American citizen and you live within the United States, then it does apply. Because the courts have ruled that even if you're not an American citizen, you have the rights and protections of the laws of the United States. Fourth Amendment is an incredibly interesting topic, and the majority of all criminal cases have some form of permutation of the Fourth Amendment. The Fifth Amendment is the right to not to self-incriminate yourself. Most people think that this means Miranda. This is not Miranda. Miranda stems from these rights. And people will say, oh, I didn't have my rights read to me. Well, just because you didn't have your rights read to me does not mean that your rights have been violated under the law. This is the right to make sure that you don't incriminate yourself. This is the right to remain silent. This is the right that has been codified by the Supreme Court, or the case law of the Supreme Court. Now, assume for a second, you're sitting at the Bears game. You're sitting next to a person, and lo and behold, Johnny comes up. Usually this couple that's sitting, they're having a fantastic time. Sally and Johnny are talking to one another. This real burly guy comes up, he pulls a gun out, he shoots the girl 10 times, empties the clip into her. She dies. He then says, I did it, I hated her. The cops drag him up, they don't make him Miranda. They take him home. They take him back to his house, they search his house, and he continues to make statements. I did it, I hated her. They drag him to the police station. I did it, I hated her. She was cheating on me with this guy. Okay? Have his right to get by with it. Just because they never read Miranda to him. Assume for a second that he didn't make this spontaneous statement, and he just was dragged to the police station and made a statement to the police. If he made the statement, sitting in custody, I didn't read him his rights, he confesses to everything, you can testify. 80,000 people can testify. Can I still prosecute the guy? Absolutely. I just can't use his statement. I got his fingerprints on the gun, I got the fingerprints on the shell casings, I've got him on live TV. So I can still prosecute him, even though he made a statement that probably would be thrown out. In the first example, where he's confessing all over the place, he's making an illicit statement. I have not done anything to get the statement out of him. You have to understand, Miranda only applies in what's known as a custodial interrogation situation. Gail, if I take you as a law enforcement officer and I drag you off to the cell, I put the cuffs on you, I end up have you make a statement in there, and I don't read Miranda, you're in custody, and I've begun to interrogate you. So that's when your Fifth Amendment rights begin to kick in. If you're running from me and I'm asking you questions, you're not in custody. So no custodial interrogation has occurred. If I walk up to you and I talk to you and I say, Gail, by the way, did you shoot that guy over there? No. Did you take the stuff from Kohl's? Yeah, I took the stuff from Kohl's, but I didn't shoot the guy. Okay. I don't have you in custody, but you're still going to come in. Okay, because I don't have you in custody, Miranda doesn't apply. This is the same problem that you have with most of the DUIs that you have. People try and say, oh, I'm in custody. No, it's considered a voluntary act to get out of the car and do all of his sobriety tests. If you can reject that, and of course continually say, if you wish to walk away from a police officer, you absolutely have that right to do so. However, I dare you to try it. The Sixth Amendment right is a very interesting right because it is the right to counsel. This is the other section of Miranda. Miranda is an amalgamation, right? Your right to counsel under the law. Sixth Amendment ends up indicating that you have the right to counsel, you have the right to speedy trial. They can't hold you indefinitely. This is what the king did. He ended up grabbing you up, Mary, taking you off to some prison, and you were never seen from again. It was like a third world country. Today, you have what's known as speedy trial. Now, speedy trial varies from jurisdiction to jurisdiction. Right? It truly does. I mean, some jurisdiction is 6 months. In the state of Illinois, it's 120 days. Unless you're out of custody, then it's 160 days. In the federal system, it's completely different there. And you have delays that are caused by either the defense or the state or the court, and it all gets put into one pot as to whether it's the state keeping the guy in custody or the defense. But you have a right to speedy trial. Now, if you want to invoke that, you can. You're not going to end up languishing in some jail somewhere. However, there are certain things that you have to do in order to invoke that right. So it's not just automatic. You have a right to counsel. If you can't afford an attorney, one will be appointed for you, which is an important right. Everybody has the right to counsel, except if I try and put you in jail. If I put you in jail, and then I arrest you and take you to court, and the prosecutor says, you know what, this is a DUI, but we're not going to seek jail time. We're only going to go for probation or supervision. If there's no incarceration that's attached to that, you don't have the right to an attorney in a criminal case. The prosecution has to say that they're going to seek jail time. If they say they seek jail time, then you have the right to an attorney. Absent that, there is no right to an attorney. Seventh Amendment guarantees many of the rules that we see in civil trials. The fact that we end up having cases in controversy over $20, which back then was a whole lot of money, but cases in controversy over $20. One of the interesting things about the Seventh Amendment is that no fact decided by a jury shall be revisited by a judge. It vests security and sanctity within our jury system. So I can never, as a judge, second guess what that jury has decided with regard to the facts of the case. This is so important in our system because in a jury trial, that is our safety valve. Judges can be political appointees. They can have certain situations where you've got a state-oriented judge where he's biased to the big corporations or what have you. That jury is your safety valve in order to get a fair trial with jury of your peers. However, the appellate courts, the judges, will not end up revisiting those facts because they want to make sure that they have faith in the jury system. The Eighth Amendment is the cruel and unusual punishment amendment. They did not want the punishment not to fit the crime. Back in the day, you know what cruel and unusual punishment was. You have a prisoner. That prisoner decides he's not going to eat his food. The warden says, he keeps throwing it back and making a mess. You know what I'm going to do? I'm going to take his hamburger, his jello, his cake, and his fruit pie, and I'm going to end up grinding it up and putting it into a loaf. And I'm going to feed him a loaf that makes sure it has all the nutritional value that he needs, but it doesn't taste so good. The prisoner files for cruel and unusual punishment. What does the judge do? The judge looks at it and says, well, that's not really cruel and unusual punishment because you're getting all the nutritional value that you need. We're meeting your basic needs. Just because it is a situation that a person ends up not liking what they get doesn't mean that it's cruel and unusual punishment. We see these come across back into the court all the time, all these petitions for habeas or PCs, post-conviction petitions saying that they were given a bad situation by their attorney, or they're filing for some habeas corpus action over in federal court saying that they're treated poorly, that we're not able to read this magazine or that magazine. You know, unfortunately, a judge ruled that prisoners have the right to basic cable over in the jail system. So they get to watch basic cable. And if anybody doesn't have basic cable, please joke with them that prisoners have basic cable. They're entitled to it. The Ninth Amendment. No rights that are enumerated here infringe upon rights that you already have. Because remember, they felt that these were God-given rights. These are not rights that were somehow, we make a statement about cruel and unusual punishment or freedom of speech. And the Ninth Amendment says that doesn't mean that you don't retain those rights. The right to hopscotch, the right to make cupcakes, the right to walk down the street. You retain all those rights. And the 10th Amendment is all the rights not enumerated here are reserved to the states, which plays a very powerful argument in what occurred from 1789 until 1865. During that period of time, the states, the Bill of Rights did not apply to the states at all. It only applied to the federal government. And it was only on the enaction of the 14th Amendment that we ended up forcing the states to end up accepting the Bill of Rights. So the first, the second, the third, the fourth, etc., those rights are all applicable to the states through the 14th Amendment, not on their own. Because originally they were designed just as a check for the federal government. And an interesting fact with regard to all of these rights, with regard to law enforcement action, is they restrict the government. They do not in any way restrict the private citizen. So in the conversation that I had with you, Gail, and I asked you if you stole the stuff from Gail, or from Cole, and I'm a police officer, and I got you in custody in the police station, and I said, you took that purse, I don't read you your rights, the statement gets thrown out because I'm a law enforcement official. I'm an officer of the government. If the loss prevention person does the same thing to Gail and takes her in the back to loss prevention and talks to her and says, you stole that purse. He said, yes, I did. But I did it because it's my kid's birthday. It comes in because they're not a state actor. None of these restrictions apply to private citizens. So Ms. Levitz and I, in our governmental role as the trustees of the village, we actually, under the law, have a right to arrest people. We have an ability under the village code to arrest and detain people. And we can effect arrest on people and detain them and keep them in a safe place until such time as we turn them over. Now, if we were to do that, you're subject to the right to all of these amendments, to the 14th Amendment. You, however, not. You have certain problems with regard to citizen arrest because you make yourself personally liable, but that's another story. None of these would apply. You can't have any restriction on your private citizen. How do I amend the Constitution? Which is something that was asked when I talked to Heidi. And the amendment of the Constitution is a fascinating subject. You have 27 amendments. There are only two ways to end up getting amendments. The first way is to end up having it passed by 2/3 of the House and the Senate, and then sent on to the states for ratification, and you have to have 75% of them. 38 states say yes, and it becomes an amendment. The fastest amendment ever passed was the 18-year-old suffrage, 3 months. Everything else, none of them have passed in more than a year. The other way that you can end up doing this is you can end up having all the states call constitutional conventions, and if 3/4 of them say yes, then you get an amendment. Of all 27 amendments that are part of the Constitution, none of them have been through this method. Another important factor with regard to the amendment to the Constitution is that the President plays absolutely no role whatsoever in amending the Constitution. They can witness an amendment, but they cannot, and their signature is not required to become an amendment. One of the most interesting facts is that the 27th Amendment, where the pay raises, was not signed off on by anyone. Nixon had witnessed one, previous presidents had witnessed them, and they had signed off on it as a witness. The person who ended up signing the 27th Amendment was the National Archives, witnessed by someone from the Federal Register. It's not required, and that's one of the things that I want you to understand is that the legislatures were put in power in order to amend the Constitution. The President, in his role as President, can do absolutely zero. You stop it, start it, or make it any other way. Some things that are not in the Constitution, which I've enumerated a whole bunch of those, and you probably can't see them because I've got this microscopic viewfinder up here that I think I stole from my 7th grade class. I was in 7th grade. Things that are in the Constitution: the Air Force, the right to privacy, the right to marriage. Those are all things that are enumerated up here. And there's a ton of things that we think of as everyday. God, you God we trust. All those things are not in the Constitution. What the courts have done is they've taken a right to privacy and put it within what they call the penumbra of rights. You are protected because these rights that we have under the Constitution, we have all of these enumerated rights, the right to be left alone. Mary does not want telemarketers calling her. You have a right to be left alone. That is a right that we have, but it's not listed within the Constitution, yet recognized by the courts. A right to privacy. So no one can come intrude on your personal matters. That's not something that they can do. You have a civil action in order for them against them to do that. These are rights that have been granted to you. The right to marriage was just made a fundamental right by the courts. This brings about some very important discussions and very interesting discussions among lawyers. Is that if I have a right to marry someone who is of the same sex, what would stop me if marriage is a fundamental right from not only just having one wife, but 5 wives? What would stop me from marrying a chair, a dog? These are obviously reducto ad absurdum arguments, and that they're a bit outlandish. No one wants to marry a chair. I don't think anybody in the right mind wants to have 5 spouses either, but that's really complicated. Well, we're not trying to repopulate the planet either. So, but it does create issues, kind of the law of unforeseen circumstances that we deal with in government. That you make something right, how far does it go, and where do you cut it off? Because if you grant the right of people to marry within their same sex, what's to stop someone from saying my religious beliefs say that I should marry X or Y? And that's something that the courts have yet to address. It's absolutely fascinating. I'd really like to see how it plays out, and hopefully in another time. I want to see it. It takes a long time to get from point A to point B. But there are various innumerable rights that are not listed by the Constitution. There are various court systems in the federal court. We have the United States Supreme Court, which is listed under the Constitution. You have the United States Court of Appeals, which is not listed in the Constitution, and the district courts, which are also not listed in the Constitution. They are enumerated by Congress and made by Congress. The United States District Court is original jurisdiction in some cases, but generally only has appellate court jurisdiction. Courts of Appeals have no original jurisdiction. They only hear appeals, and the United States District Courts have original jurisdiction over federal matters, cases of controversy and diversity, and any kind of constitutional questions. Generally, it goes from district court, U.S. Court of Appeals, to the United States Supreme Court. And it goes upwards. They don't hear new facts, and that's a common misconception. Your husband's a lawyer, and you know this, but the facts are only heard at the district court level. They're never heard at the United States Court of Appeals. They're never heard at the United States Supreme Court. Only the laws interpreted in those top two court systems. With regard to Illinois, we work very much the same way. We have the circuit courts, which you can see over here at Rolling Meadows. We have the appellate court, the Court of Appeals, which is downtown in Chicago. And then you have the Illinois Supreme Court, which is downtown Chicago and in Springfield. There are different sub-circuits throughout the area in Cook County, and there are different courts of appeals throughout the different districts throughout the state of Illinois. There are 5 separate Court of Appeals, and there are all the sub-circuits and sub-circuits throughout the state where we select judges. A judge, however, that's elected here in Arlington Heights and lives in Arlington Heights has jurisdiction to go down to southern Illinois and can sit and hear cases in southern Illinois. And they frequently do exchanges all the time in order for courts to end up hearing different types of cases and see different kinds of laws. And it's very fascinating for me to travel statewide and litigate cases statewide, because if I go to Rolling Meadows and I sit in a courtroom, I'm litigating in a criminal courtroom. It's nothing but criminal cases. If I go down to southern Illinois, or I go out west to western Illinois, I have to sit through a parentage case, an adoption case, a foreclosure, and a property case before I get to my case. Those judges have a vast swath of things that they do. And one would argue that they are far more well-versed in their breadth of the law than those who just hear one area. Although they become experts in that one area, they don't have that same exposure, which is why they like trading places sometimes. The United States Supreme Court, how does it get there? We go this way. We go up to the state Supreme Court, appellate court, and state Supreme Court. But in order to get to the U.S. Supreme Court, if a case is decided here in the state of Illinois, it has to go up through this route first to get to the United States Supreme Court. The U.S. Supreme Court does not hear cases on a whim. You have to have a constitutional question in the state of Illinois that is a U.S. constitutional question. If the Supreme Court says, no, this is a state of Illinois constitutional interpretation of the rights under the Constitution of the state of Illinois, i.e. the pensions in the state of Illinois, it does not go on to the United States Supreme Court, because they give deference to state courts interpreting state constitutions. So that's why you did not see this go on to the United States Supreme Court when this came up. It's actually one of my more favorite
participating in an endeavor in which the ultimate decision might be death by electrocution? Ma'am?
I think it should be left up to the victims' families rather than the courts.
The defendants in this case are charged with robbing a convenience store, and then in a most cowardly fashion, shooting the clerk in the back. Now, if sufficient evidence is offered to prove these facts, you think you could...
Try.
You'll do.
Criminal court cases revolve around prosecutions and defenses. And this is a prime example of prosecutions. One of my favorite movies of all time, my cousin Vinny's, The Two Utes. But in this case, the prosecution ends up picking the jury, and you try and end up the trial by jury, which was enumerated in the Constitution. Your constitutional right is played out every day in Rolling Meadows. Every day. The prosecutor gets to pick who he thinks is going to be on his side, and the defense gets to pick who they think is going to be on their side. The defense and the prosecution end up getting to present their cases, and that is part of your job as a prosecutor or a defendant. According to the American Bar Association Standards of Criminal Justice, the duty of the prosecutor is to seek justice, not merely to convict. They're supposed to look and make sure that things like the Ruiz case up in Wake County, or the Rivera case, excuse me, where the guy stayed in jail forever and a day on a false confession, doesn't happen. I actually got a call from Anita Alvarez today when we were discussing some stuff, and it was interesting. She understands her role as a prosecutor, and it's just fascinating to me to end up having discussions like that with people that are elected officials that completely understand that there's a justice aspect of cases, as opposed to just merely, let's get as much as we possibly can on any given case. Prosecutors are responsible for filing charges and filing criminal cases against people who have been violating the law in the jurisdiction they represent. And the duties of the prosecution are to persuade the jury of the defendant's guilt, to prepare the opening statement, display all the evidence, get the testimony from the witnesses, cross-examine witnesses, and present a closing testimony, a closing argument. Now, what does the defense do?
The defense calls as its first witness Ms. Mona Lisa Vito.
Oh, I object, Your Honor. This person not on the witness list.
This witness is an expert in the field of automobiles and is being called to rebut the testimony of George Wilder. Your Honor, would you please instruct the bailiff to escort Ms. Vito?
Our job is to call witnesses, no matter how reluctant they may be. And in this case, as you guys watched, and no, she wasn't really happy with my cousin Dave. She was an absolutely fantastic witness, and it was a wonderful, wonderful recitation of Howard Drive trains and how that worked out. I really liked that movie. I could watch it 100 times. The duties of the defense. The duties of the defense. A defense attorney is a defendant's champion, an advocate, and an advisor. We're supposed to speak for them when they end up going into court. That whether right or wrong, whether they're guilty or not guilty, our job is to speak for them. Our job is to act as an advisor, to sit down and explain to them. Within the four walls of my office, I talk to these people as if I am as honest as possibly can be. Outside the four walls, I am their advocate. I am the person who speaks for them because generally they can't speak because of the fact that the Fifth Amendment says that anything that they do say can and will be used against them. And they understand that they have a right to remain silent. I, as a defense attorney, get to speak for them. You have the right and privilege of every criminal defendant to have legal counsel, whether or not they can afford it, because the defendant is innocent until proven guilty. This is not a phrase that you will see within the Constitution. Innocent until proven guilty. It's not there. It's just simply been defined by the courts of common law. They're to be proven guilty beyond a reasonable doubt, and innocent should never be denied legal counsel ever. The example that I gave to you, I don't agree with the disposition of that particular court case or ruling. However, the practicality is in small counties, they simply don't have the resources to do it. And you see it a lot. You don't see it as much in Cook County or Chicago. You do see it downstate all the time. The duties of the defense are to persuade the jury the defendant is not or has not been proven guilty. Cross-examination of the prosecution's witnesses. Require the prosecutor to prove guilt beyond a reasonable doubt. And the New Jersey versus TLO case, I'm going to go ahead and skip. This person reported, but I prepared two cases to discuss with you guys as to search and seizure aspects. If you'd like for me to discuss them, I can, or I can take questions at this point. Does anybody have any questions about the Constitution per se? Not the Bill of Rights, but the Constitution. Yes, ma'am.
How much of it is based, or is any of it based on English common law?
The Constitution itself was something that was taken from many of the Virginian ideals, the Enlightenment, and many of the free-thinking movements at the time. The English common law, remember, derived from the crown. And the English common law, all the authority came from the divine right of the kings. And that, stemmed from from even previous to the Declaration of Independence or the Constitution of Magna Carta. And the 1215 Magna Carta with King John was the defining document of liberty of free men, because it took away that absolute right of kings and began to give rights to the people. Very slow process, another 500 years before we got to where we were at. However, sometimes. So, yes?
I was gonna ask you too, English common question. You were saying, or maybe I misunderstood you.
Sure.
That the right to marriage had been established by the court recently.
It says a fundamental right.
But by the very fact that the states were issuing marriage licenses for 250 years, and people had the, right to get married, except not to the same sex, wasn't that right established the minute the state started to say, here, we're issuing marriage licenses?
That was Huckabee's argument last night in the debates. The
God,
problem,
that scares me.
that was his very argument for the court clerk in the state of Kentucky. That, this was something that the Constitution of the people of the state of Kentucky had determined was what they wanted to live by, and the federal government had no
I didn't
authority.
mean that way. I meant that because all the states all got together, I didn't mean that the state itself established a right. Now I see why you, I meant that the fact that for 250 years, we went around, people, the states give their imprimatur saying, here's a marriage license, you can get married.
I understand the counter argument was there were certain states that banned interracial marriages
Right.
as well.
Yeah.
And the Constitution, being the living document that it is, ends up being interpreted over a period of time, and it reflects the social mores of what society is at the time that the rulings are made. Now, you take, Brown versus the Board of Education, or go back to Plessy versus Ferguson, you're going to see two completely different views from the Supreme Court as to what they felt the social mores of the time were in the interpretation of what due process and what rights were afforded to certain people. That has changed. You think about 25 years ago, you never would have thought about your cell phone being searched being an important factor in any kind of issue. One of the problems, and it got to the point where there was a gentleman, and I'm using the cell phone because that shows how technology and your life in itself has changed. Aside from Judith, which I'm incredibly envious of having just a flip phone, most of us do have those. There was a case out of Detroit, I believe it was Detroit, where the detective ended up arresting a young lady, ended up taking her phone, ended up, no, it was in the 7th Circuit. I apologize, it was not in Detroit, but took the phone, ended up looking through, there were some photos she had taken of herself, and they were not really for publication. He ended up taking one of those photos and had it, just sent it to his own phone. The court said that although it was not illegal, it was reprehensible what he did, but he didn't violate any rules under the Constitution. This was prior or previous to the ruling in the case where they ended up having the cell phone issue. So,
But wouldn't it be more accurate to say that they didn't establish the right to marriage a couple of weeks ago? They extended the right to people who wish to marry within same sex. In other words, the right existed before, they just weren't allowed to be part of it.
what has been defined as by the court is that marriage is a fundamental right. It's a right of all human beings. It's the same as your right to free speech, your right to be happy, your right to end up procreating. They're all fundamental rights that we have. And that's something that, for good or for bad, whichever side of the fence you sit on, that's something that has been made law now, and there's no way around it. I understand the argument. The argument is the states had the ability to do this in the past. Why not just respect the state's ability? It was a state right. Why all of a sudden is the federal government taking over and enumerating what previously under the 10th Amendment really should have been a state right? Again, that was Huckabee's argument. The problem with that is that you're essentially denying a due process right to people, because when we would get people coming into the office who were a married couple, or they had been married in another state when marriage was illegal in this state between same-sex couples, you would have to go through a and your spouse got sick, you weren't allowed to see the person in the hospital, you weren't allowed to inherit their property, you having
Social Security.
Right, it was an incredibly difficult process, and we actually had to go to Chancery Court in order to have, and Chancery Court is the court of equity over in Cook County, that essentially can divide property and award property and takes things that don't have monetary value and can make sure that it gets from one person to another, such as a building or stocks or those sort of things. If it's something that has monetary value, it goes to law. But in that case, we would have the marital estate essentially handled by the judge, and the judge would look at it and say, okay, I understand you want to you want to sue to quiet title. We'll go ahead and give, because you two own it together. I'll give it to you and not to, her sister or in some intestate successions. That was the problem that arose, and it became a very complex problem. There were certain attorneys that they became very proficient at doing these types of divorces, even though they weren't divorces.
I just want to establish again, I'm not saying it's a state's right. I'm saying that the states recognize a fundamental common law
They
right.
didn't, though. They didn't. One state wouldn't necessarily recommend. There is.
No, I meant they recognize the right of people to marry, not marry to the same sex, but by the fact that they were issuing marriage license, they were recognizing people had the right to get married. People had the inalienable right to get married.
But they only had the right to get married to certain other people.
And that was an infringement of the fundamental right, in my opinion, which is not a lawyer.
Again, whichever side of the fence you sit on, they define marriage as a fundamental right, and fundamental rights are the only ones that are affected by the 14th Amendment.
Right.
Other rights are not affected by the 14th Amendment. So a fundamental right to a right by trial by jury, a right to not incriminate yourself. Those are all things that are fundamental rights under the law. They made marriage one of those fundamental rights, even though it is not enumerated within the Constitution.
Or, in my opinion, they recognized that it was a fundamental right. I don't think the Supreme Court established that right. That was there pre them saying anything.
Again, that's depending on which side of the fence you sit on. Either they're judicial tyrannists and activists, or they're simply defining what hasn't been defined before, which is their role.
Yeah.
So,
And that's what I think they did. I mean, they didn't make that right. They recognized that right of people to marry.
Again, I understand what you're saying.
Yeah.
Yes, you had a question? I'm sorry.
Yes, and it refers to the House of Representatives. Has anybody tried to amend that 2-year term thing? Because it makes it very difficult, doesn't it? When they barely get in office and they have to start running for office.
Raising money.
The raising money portion, and I understand what you're saying, but think about 230 years ago, when you had to run for the House of Representatives, and you have a running from the state of Georgia, and you had to go all the way up north. You get there, it's a month travel time. You get there, you settle in, and then you got to come back. Now you can be home in a matter of hours, no matter where you are. One of the reasons that they felt it was so incredibly important to have that 2-year cycle was that the House of Representatives, because they have so much more power than the Senate, they wanted them to keep in touch with the electorate. They wanted them to not disappear. The senator has a term of 6 years. And because it's 6 years, you may not see that senator for the first 2 or 3. Then comes time for the re-election, all of a sudden his face is in the paper all the time, and he's shaking hands and kissing babies. The representatives are supposed to be, since their districts encompass a smaller area, they wanted them to be in touch with the community. But I understand what you're saying.
So it never has been tried to be amended?
No, because they feel that it is appropriate to keep it the way it is. And remember, most representatives don't have the incredible power that the chairman has. The chairman really hold all the cards in the House of Representatives. Their districts and redistricting is pretty much locked up. They know that they're going to be reelected. Because when it comes time to redraft that to the party in power, then those district lines generally fall for them. Yes, ma'am.
You said that this case about marriage might cause all kinds of problems. Didn't Utah limit polygamy? Didn't they say that because there was so much marriage going on among Mormons, wasn't Utah able to do that and say they could not live one more?
Well, again, that was done, but will it stand the constitutional test? And I didn't say that it would cause a lot of problems. I said that I thought that there was a great deal of legal discussion between it, and it's raised some really interesting topics. between us, because lawyers talk among themselves about legal issues all the time. We find it incredibly fascinating. Does it really limit someone? If it is a fundamental right, then what's to stop you? And if they do limit it out there, what's gonna stop the courts from saying no? Do we have an overriding, they generally couch it in terms of the police powers of the state, or public safety, yeah, which is the police powers of the state. So this is what the direction we want to go, and we'll say, okay, you can have one person, but you can't have multiple people.
So you're saying
It's possible.
you're not sure that a Utah law, or whatever they call it, would stand up to a court case?
I don't know. I really don't know. I think it is a really, I think that the people who would lobby for that would probably have a very good position based on the fact that this is a fundamental right now. And if marriage is a fundamental right for all people, then why can't, if you've got the sister wives or whatever it is that, you know, you see on Bravo Channel, or if I forget which TV program it is, but the sister wives, if they all want to marry one guy, what's the problem with that? If it's a fundamental right, and they're all agreeing to it. You know, I think that's therein lies the problem. If you make it a fundamental right, how do you control what that fundamental right extends to? And where are the limitations and boundaries? And again, it may be up to the courts to decide that, because since you have a fundamental right, nobody in the legislature, nobody in the state legislatures, nobody in the Congress, the executive branch can't do it. They can't limit that. It's got to be something that the courts have got to redefine.
So you think we're just seeing the beginning of that?
I think you'll probably see more litigation in it, because you and I both know that there's people out there that will take things to extremes. And you've got people that, you know, we walk outside and we walk out our front door, and there may be that person who's a little odd, 6 houses down this way or 6 houses down that way. Everybody's got somebody who's a little off in their neighborhood. That person may be the person that decides to take it up.
I have another question about the right to bear arms. Why, I thought the interpretation for a long time was that only applied to militias.
That was the argument, yes, ma'am.
Right. And now it's anybody.
The argument was that, well, it was intended so that people could have a militia and they could end up protecting themselves against, you know, foreign invaders. We didn't really have a set army, so therefore we wanted everybody to have a musket and to be able to be mustered out and go and protect, you know, the countryside. The courts ended up looking to Patrick Henry and various other writers, and the practicalities of today. Most states, with the exception of Wisconsin and Illinois, they were the two last ones to end up changing the law, allow some sort of concealed carry. And some of them were a shall issue state, some of them were a may issue state. It really depended on where you live. If you lived in Texas, then they signed off on it right away, and it was a shall issue state. No questions asked, as long as you passed a criminal background check. In places like New York or California, it was a may issue state where you had to show good cause in order to get a concealed carry license. You had to show that you were you had a threat, or you had satisfied some sort of security issue that you had that you needed. Well, even police officers, you know, they didn't need that because of the post 9/11 ruling that, you know, retired police officers can end up carrying with a letter from their chief. So that really wasn't an issue. All retired police officers, as long as they have that letter, are perfectly fine to carry within all 50 states, anywhere.
But don't you think it's really gotten out of hand?
Well, in the state of Illinois, you have only seen, since concealed carry started, you've only had 3 cases of people utilizing handguns that had a concealed carry license that I'm aware of. The first one was about 3 days after the concealed carry came down and the first licenses were issued. A gentleman ended up apparently threatening one of his rentors or rentees, I forget which one it was, with a handgun, and then, you know, when he threatened him, he ran and he tossed it and the police found it. The second one was a case called People versus Hansen, which was out of Lake County, which I actually handled. And
Lake County?
it was in Lake County, yes, ma'am, where a gentleman who had a federally protected, secure area had a person drive onto that property that on the eve of one of the big terrorist actions, and it was an unmarked box truck, and he went outside and told the guy to get off the property. The guy alleged that he had a gun, and because he had a concealed carry license, they arrested him. third case was the gentleman, I believe, that was down by the booth, and he ended up killing his girlfriend. It was right by the L line right there. Yeah, in the current issues. Those are the only three that I'm aware of, and so, the vast majority of either gunplay or shootings that you see are from people who just simply, they're not supposed to carry guns anyway. The people that end up getting the concealed carry license by and large, I did a presentation on it with the Chief State's Attorney of the county in charge of this district, as well as Senator Murphy, Trustee Farwell. We had several other people there as well from downstate, and the ARDC administrator, deputy administrator, excuse me. And part of what we were talking about was that 99, I think it was 98.6 of all people who have concealed carry licenses to the United States don't violate the law in any way. 1% of those remaining, so 99.6, that 1% from 98.6 to 99.6 violate by carrying in the wrong area. In other words, they go into a school, they walk to a police station, only 0.4% actually have any kind of criminal activity. And those are statistics from the state's attorney, those are not from me. So, I think most people who end up getting concealed carry and jumping through all those hoops are really concerned about not having that right taken away. So they're not going to do anything to jeopardize that. You're going to find an aberration, like the currency exchange, but I don't think by and large it's a real problem. I have not seen it in my practice, and I have not seen it throughout the state. I think your chances of being shot by somebody who does not have a concealed carry license are far greater than being shot by somebody who does have a concealed carry license.
People carrying guns who don't honestly need them, just for protection or something.
That may be. I mean, by and large, it's kind of a pain in the butt to carry a piece of steel, and it's not exactly the most comfortable thing in the world. So I don't see why you would want to carry anything in your hand.
It makes them feel.
But you're working on. You go downstate, and particularly downstate when I was down by ISU, the state's attorney prior to the CCW statute going into effect just said, I'm not going to prosecute UW crimes. I'm not going to prosecute unlawful use of weapons. I believe that you can conceal carry. And he just stopped prosecuting. And the reason is because you go south of I-80, you're looking at a completely different mindset. I mean, your response time here in Arlington Heights is probably about 4.5 minutes, and on a bad day. And that's if everybody's on the north side or the south side. You probably only about 4.5 minutes. If you end up going downstate, you go south of I-80, it could be 30 minutes or more. The closest police officer could be 30 miles away from you. So, I understand there's a different need for it downstate, especially when you're traveling or you're in some rural districts. But, here, there's a police officer, probably every 30 seconds away from you at any given time. We're lucky in Arlington, we don't have to deal with a lot of that. Yes?
I have real weird mind, okay? On cruel and unusual punishment.
Ma'am, you should see my clients, you're not even close. You should see my clients, you're not even close.
Okay. Well, you haven't heard the questions yet. What about, for cruel and unusual punishment, what about forced feeding?
No, actually, that was a Guantanamo Bay issue.
Yeah.
Very interesting because the detainees at Guantanamo Bay said, trying to say that they were cruel and unusual punishment. There were two different schools of thought, or two different angles of attack. Number one, they weren't on U.S. soil, so since they weren't on U.S. soil and weren't U.S. citizens, as we discussed, Fourth Amendment doesn't apply to them. However, they're U.S. detainees. Since they're U.S. detainees, there was the force feeding, and one of the inmates that had left scars in the back of his throat because they were jamming the NG tube up into him. They indicated that, based upon his repeated desire to not have any food, trying to kill himself, they had no other choice but to force feed the individual. The right to life is another one that has yet to be really fully enumerated in the Constitution or by the courts, but that was the basis for which they ended up taking a look at it and saying is the right of to keep a person alive. You're a detainee, you're a person that I have a responsibility for. Since I have a responsibility for, I have to make sure I force feed you to keep you alive. I can't let you die on my watch.
I'm really confused on this part. Like, it isn't US territory?
Guantanamo Bay is not, since it's one of these gray areas.
I was gonna say, because if
There's
Senator
a lease.
McCain is a US citizen because he was born in
Well,
Panama, where we were
remember, you're talking about the
military
difference
base.
between the U.S. military bases and U.S. soil. But the problem is Guantanamo Bay is a gray area because of where it sits and because of the agreement that they have with Cuba.
If there isn't a military base with all those military guys based there,
Ma'am,
please explain what a military base
And
is.
I agree with you. You're asking me to explain things that I can't because, some things are
I meant it.
legal fiction. Remember, they put them there so that they were enemy combatants. If they put them anywhere else, they would be prisoners of war and they would have certain rights under the Vienna Convention and everything else, which is why they stuck them in Guantanamo. They kind of stuck them in limbo there, and it's a legal limbo. And that therein lies the problem. I can't explain what is unexplainable. It's U.S. soil. There's a really crummy golf course over in Guantanamo Bay with no dirt on it. There's a bunch of Cubans that stare at you over the fence, and everybody walks up and they all talk like this when they're out, so they can't breathe their lips. But
Now, you said the authorities felt they had the right to keep this guy alive. Does this guy not have the right, if he were American citizen or American soil, would he not have the right to choose when he died?
And
Except in
that
Oregon.
is a problem. I understand the conundrum, and those are the big questions that the Supreme Court justices get paid to end up,
But some states have decided that their citizens do have the right. Oregon.
Well, the state has exclusive jurisdiction over murder. But the point is, if a state says it's not murder, then it's not murder. If you go to Oregon and you want an assisted suicide, then you could do so. Because the state's not going to prosecute you for the murder of the person. However, you come here and you do it in the state of Illinois and you inject somebody with a bolus of sodium chloride. And they end up dying because they get a seizure. Because you want to terminate their life early, that can be considered a murder. Now, I had a doctor that did just that when I was chief of medical prosecutions, and he decided to end another patient's life early by injecting potassium chloride. The state did not end up prosecuting. When they didn't prosecute him, I think the guy had roughly about 2 hours to live. But he lost his medical life.
So that's the doctor, that the patient should have the right.
Again, in this case, the patient didn't ask. The guy just did.
Well, in Oregon, you can't do it unless you're capable of doing it yourself.
And, whether that's right or wrong, or whether that's moral or immoral, I can't say because we don't have a law to that effect here.
So in
But it
Oregon,
hasn't been decided federally whether or not you have a right to die or a right to life.
so if Oregon, a person took his own life, who has standing to take that up to the Supreme Court? I mean, to take it through the court procedures, to figure out,
If you kind of look at the Pierre Chavez case, remember?
that was Florida.
But remember way back when, it's generally the next of kin. So in that case, you've got a family member that's trying to take you to the system, and you've got competing family members, the father and the mother saying one thing, the husband saying another. It's who's the next of kin, who has standing. And, in different states, you're gonna have different setups, whereas, in the state of Illinois, let's say it's, grandparents generally don't have standing over grandkids. They don't have a right to visitation, they don't have a right to automatic custody. Whereas in other states, they have, grandparent visitation with the grandparent that have standing to make that argument in a situation where a child is dying from leukemia. Maybe it depends, it varies from state to state, because each state has reserved its own rights, it gets to govern itself the way it wants to. I can't, although medical marijuana or recreational use of marijuana here is illegal, Colorado, you can do it because that's the way they want to govern themselves. Federal law overrule that? Yeah, it does, which creates that weird tier system. And, you talk about the supremacy laws with the Constitution, it created a real problem with medical marijuana, because medical marijuana here in the state of Illinois is legal. However, the federal government still said it was illegal, and since it was illegal for the federal government to do it, and it was legal for the state to do it, we as attorneys couldn't end up assisting in any kind of medical marijuana laboratory or clinic or whatever you want to call it, because we would have violated professional standards by assisting somebody in breaking the law. Now, they just come back to the ruling on that, but that's here or there. It shows that there's that disparity between the two. You can grow on state, or you grow marijuana in the state of Colorado, you could end up smoking it, but I could come in as a federal, ATF or a DEA agent, arrest you and prosecute you under federal law.
Have any of those cases come, have any of those been tried yet? Because that was going to be a conflict.
They issued a directive that they weren't gonna go after low-level marijuana people, and that was my understanding. They've also issued several other directives saying that they couldn't end up they wanted low-level drug users to be moved out of the system earlier. They're really, in my opinion, the majority of the people that we see locked up in penitentiary, both federal and state, have to do with narcotics in some way or another. A lot of it has to do, in the federal level, you deal with more high-end people who are moving the product. In the state system, you've seen people more with, really severe mental health issues, and you're seeing people with drug abuse problems, which, the dollars probably would be better spent dealing with those problems as opposed to incarcerated, but I digress. That's not a constitutional issue, that's just my personal opinion. I mean, I'd rather see these people getting treated than not re-offending. So, yes?
Well, anybody else?
Yeah. Go ahead. Oh, yeah, no, that's okay.
All right,
I thought you were yielding the floor.
the fourth meeting I was really thinking of was the suffragettes, and I don't remember that anybody at that time, said you can't do that. Sometimes it seems to me like these rights get more or less like put aside when somebody wants to do what they want to do, because like at Rikers, there's been several programs on the fact that there's people at Rikers that have been there without trial for over 2 years. And in solitary confinement, and all, there was the guy that committed suicide back about, 3 or 4 months ago, had been over 2 years at Rikers, was eventually let go. And it was over him supposedly having stolen a backpack.
I know what you're talking about. That emphasizes your right to speedy trial. 2 years in an institution like that, the average, to equate it to what you see here, so what you understand in the state of Illinois, and especially in this area, if you get a murder case and you get charged with murder, let's go to marriage, concealed carry issue. You go out, you get a concealed carry license, somebody comes up to you and tries to rob you, you shoot them, and you're taken over to the police station. They don't believe your self-defense, you're taken over to the jail. You're taken over to the bond court, they hear you at bond court, and they said $1 million or $3 million bail. You're going over to 26th Street, and you will stay at 26th Street until you're ready for trial. I could file a speedy trial demand, and that speedy trial demand would make them have a trial within 120 days. But I don't have any police reports. I don't have any witnesses. I don't have any DNA. The average DNA takes about 18 months in a murder case to get back to me. Yes, because there's such a backlog at the state police. So the average murder case on a low end will go somewhere between 18 months to 3 years. Now you can't post $1 million, $3 million bond. You're gonna be sitting over there for 18 months to 3 years until I can get all of the evidence from the state to go forward. Can I go forward without the evidence? Absolutely I can. We can go to trial tomorrow if that's what you want, but you're at a disadvantage because you don't know what the state's gonna say.
Is that why all those people are sitting in Cook County Jail? Precisely.
You've had, people who, the evidence just is not being processed, it's not being processed in a timely fashion. Unless tomorrow you're gonna solve the state's budget woes, and we're gonna somehow come up with funding, then great, they don't even have a budget right now. So, making sure that they can end up processing DNA it takes a long time. I'm talking to people at the DNA lab, they're really, the state police lab, they're really, really bright people, dedicated public servants, I have a lot of respect for them. But they end up, unfortunately, they're under such stress to get all of this stuff done because they've got a backlog of cases, and it takes a while to do this the right way. It's a fascinating procedure. If you ever get a chance to go learn about DNA firsthand, I really recommend it. It's really fascinating how they exclude people. So, yes.
Couldn't, like, the judge in California told the California they had to either get rid of the inmates because, because of the overcrowding.
Right.
Couldn't someone, I don't know who,
They
would
did
have
that.
standing?
They did that in Cook County with overcrowding, and they
Right.
started releasing people on electronic monitoring.
But I mean, on the principle of you have the right to a speedy trial, and it's the state that's holding it up because they haven't properly staffed. Just
You
like
have-
they haven't properly built enough prisons.
I understand, I just don't know of any judge around who's gonna end up saying, yes, I'm gonna hold the state to task. It's gotta be a federal judge, because the state judge is gonna end up getting jammed. Federal judges are appointed for life, they are good behavior, they can get impeached if they are out frolicking in the town square with some woman in a fountain or something like that. Who was the senator from Arkansas who did that? Yeah, but you know what I'm talking about.
exactly.
Okay, you do stuff like that, you
That's
get
good.
impeached.
That's just the title base.
Yes,
Yeah,
exactly.
title base. Yeah.
But if you do stuff like that, you get impeached. Impeached just means you're charged. It doesn't necessarily mean you're removed from office, which is a common misnomer too. But it would have to be a federal judge that ended up deciding that.
Where do you stand on merit selection of judges then?
You know what, I think there's arguments both ways. Merit selection of judges really puts you in a position where you're going to get political people put on the bench and possibly not the most qualified people. Election of judges has the same problem
I
because.
was gonna say, you get political people.
I know who the judges are because I see them every day. And I know their reputation, and most of them either went to law school with me or I knew them in the state attorney's office through my practice. But even, with me running through the courthouses all day, I don't know everybody is up for election. You guys are at a much worse disadvantage because you don't know the people. You just kind of trust what the evaluations are if you read them.
Yeah, the people that vote don't pay attention when they have all the recommendations from several,
Bar association.
bar associations, and they all say that someone is disqualified, they still get elected.
And I realize in the way that it works, you obviously know, they get elected, and then to get retained, they gotta get 60% of the people to vote them off, which, has happened, I think, twice over the past 40 years. So, and then, you have to be really bad in order to get voted off. So merit selection has its bonuses. You would have to have a nonpartisan group. You would have to have somebody who's not, connected to politics at all. And they'd really have to go based on a merit selection issue. But then that merit selection issue, you're giving a whole lot of political power to people who could end up saying, oh, you believe in abortion, you believe in abortion, you believe in abortion, you believe in abortion. The rest of you guys, I don't want you because you don't believe in abortion. You can end up swaying how things are coming out with regard to the political process. Additionally, if you have a merit selection, then that person may be beholden to somebody, and you get into a ruling such as the pension issue, and they can't make an independent decision.
I'm sorry to interrupt. I think Tom could go on. He'll leave me because he enjoys this, and I know you have many questions, but we had decided that we would conclude the program at about this time. There's lots of dessert and refreshments, so maybe you can mill around, and maybe if Tom has time, he can visit with you. And thank you very much. We appreciate it.
I don't get paid by the word or by the hour, not here tonight. But thank you guys. I really appreciate you having me. Obviously you've seen, I have a great deal of passion for this. If you have any questions, you're welcome to talk to me at any